Good morning, class. This company law, business law. I'm going to start with sources of laws in Kenya. Sources of laws in Kenya. We start with the Constitution, which is the most important document. Legislation, that's the parliament, or acts of parliament, or statutes. Then you have delegated legislation. Then we have case laws. These are precedents. Case laws, that is the judge-made laws. We have also African customary laws. We have the Hindu laws. We have the Islamic laws. All these are the sources of laws. What do you mean by sources of laws? Is that where the rules of laws are found. It talks about the origin of the rules of laws and principles of laws in Kenya. So, which constitute the applicable in Kenya. Now, we shall look at the literally what it means by laws. Of course, we have seen it before. Laws are rules and principles which are there to govern, to make sure that people behave properly, they are disciplined, they are with good conduct, they don't interfere with other people's affairs, they don't harm others, so that we have the harmony in the country. Those are laws. So, but we have the sources. Where do they come from? First of all, we have the Constitution, which is the main document. Everybody contributes to the Constitution. You remember, the Constitution now, the current Constitution was promulgated in 2010 on 27th of August. That time the president was Mwai Kibaki, and is the one we are using now. Any laws which are contradicting the Constitution are null and void. They are irrelevant. That's why they say the Constitution is the supreme. So the Constitution, other laws are derived from the Constitution. Now we have legislation, whereby we have representatives like your MPs in the National Assembly. These are the ones who make laws. They can also repeal laws, that is, change the laws to suit the current situation. They are empowered to make laws in the country. And we shall look at the sources and the process of making those laws. Then we have laws also made by other people, empowered by the parliament or act of parliament. That is the Parade Act or Enabling Act, which enables, like a minister can make laws within his own ministry. The Minister of Power can make laws in his own ministry, or we call them cabinet secretaries. The governor can make laws in his own county. So they are empowered by the Enabling Act or the Parent Act. We also have the Hindu laws. We have the customary laws, African customary laws. We have the Islamic laws. That is how they carry on their marriage, succession, separation or divorce. And once these laws don't concur with what is in the Constitution, then the laws in the Constitution will prevail. Laws are, some are unwritten, some are written. Written laws, like the Constitution is written laws. Parliamentary Act or Acts of Parliament are written. Delegated legislation are written. Those are in writing. But there are those ones which are not in writing, like the Hind laws, the Islamic laws, the African customary laws, and so on. We have the principal sources of laws, and these are applicable throughout Kenya. Then you have the subsidiary sources of laws. These are applicable like Islamic laws, Hind laws, and African laws. The constitution is supreme because it is the one where other laws derive their validity from. Anything or any claim about a law which is contrary to what is in the constitution, then that law is invalid. Or anybody doing something which is not according to the constitution, then it is null and void. It can be, when it's taken to court, it can be nullified. That is when it comes to judicial review. So the Constitution of Kenya shall take the supreme position in the country. So I've just said, let me summarize. Laws are made by you in the Constitution. You remember everybody contributed before that that Constitution was promulgated. Laws are made by Parliament. And laws are made by also judges. There are those laws which are made by the judges. Like let's say the Mumbi, Judge Mumbi, say that if a child is born out of wedlock, then the child must take the name of the father. That's a case law. And it's a precedent. Why? Other courts can actually refer to that law. The Lucy Waithaka, in the court in Nyeri also last year, made a law that whether married or not, a female child is entitled to the sharing of the property of the father. So that is a case law. Now, we have the government bills. When the lawmaking process, we shall look at a bill. A bill is a draft. You make a draft, it's a statute. And then this bill is published in the Kenya Gazette so that the MPs are aware, the public are aware of the new coming law. And then after published, it is taken for first reading. In the first reading, there is no debate in the House. They just the clerk of the National Assembly just reads the bill. Then second reading, the bill is debated, and once it is debated, it's taken to the committee, the House committee of that relevant bill. If it's education, the Education House committee will look at it, make recommendations, or make a report, and return to the House. And then once it is brought to the House, then it is fully debated by the MPs, exhaustively debated. If there are any changes to be made, then they put it on to vote. And once it passes, taken to the third reading. Third reading is when the bill, if it passes, taken to the President for assent. That is, it becomes an act. And because before it becomes operational, then it has to be also gazetted first. Thank you.